first of all, thank you for inviting us for this interesting session. Uh, and thank you, sir, for agreeing to participate in this. Uh, I think I'm very glad that this is the right time to have this discussion, and I'm just referring to the recent data protection bill that has come for the public consultation. Uh, just since you are one of the architect of the privacy bill, just wanted to take your view on this current 2022 bill that has been released last week. Uh, what you have as a preliminary views?
I just had occasion to run through it carefully. It requires a lot of work on that. Some of the good concepts have been put in simple language, but it has miles to go before it can be called even near perfect solution to the problem that we are facing right today. Oh, there is a lot of work to be done on various sections, and each one of them has to be carefully scrutinized from a legal and jurisprudential methodology. And you cannot forget that way back in 2018, there was a committee of experts which was set up by the government of India to go into this question threadbare. The committee spent almost a year and 11 months or 10 months or something like that, looked at all that was happening everywhere in the world, came out with different concepts which are fundamental in data protection, came out with a report and a draft law. I wish whoever was the architect of the current 2022 bill had really looked at it and seen why it cannot be followed. Some of the concepts have been just left vague and loosely worded, and it is going to create infinite amount of confusion, and of course, it's paradise for lawyers, headache for judges.
Absolutely, I think you are spot on. And one specific thing that they left on very silent about is the non-personal data. So, and what do you think, in your perspective, what they should cover once this bill gets finalized and enacted as an act?
Sachin, you know why the London Tower is famous? Because it contains the crown jewels. You have seen the security around it. Why Fort Knox is famous? Because the security it gives to the bullion that is deposited by the federal government in USA. So basically, all this cyber security that we have been hearing since the morning, what is it intended to? To ensure that the data that you have is not unauthorizedly accessed, or is not corrupted, or is not stolen. Basically, therefore, you have to devise a law which deals with the subject of what is important. Technology is only a tool. Technology is not something. Yeah. The technology is not the end all of life. Life is me and you. True. How can technology help us? How can law help us should be the objective. If that is the objective, then there won't be any problem with any law, any technology.
Correct. But do you think this entire bill, data privacy bill, should also linger around the privacy by design?
Yes, privacy by design was again another concept. You're right.
Yeah.
Privacy by design is a concept that every individual, whether it be a private individual or a business entity, should have this idea of carrying out this privacy with regard to personal data. And therefore, there should be constant monitoring of the privacy of the personal data, constant education of all the employees who are concerned, who are dealing with the personal data, so that they deal with it as an important issue which needs to be protected. If you remember, way back, there was this question of women, harassment of women. There was no law at all in this country. Supreme Court came out with guidelines, Vishakha guidelines. That later on became actually the statute that is in place today. Now there, one of the concepts was that it was obligatory on every employer to put up a notice board saying how women should be treated. educate each and every employee on how women should be treated at workplace. The same concept must apply in privacy by design. Unless that is done, people today don't have an idea of what is privacy, why it needs to be protected. That is where you need this concept of privacy by design.
And one of the things that has categorically captured in this particular bill is data empowerment and protection architecture, which is called DEPA, which empowers the individual to control their data on their personal data. So I think the privacy by design will definitely have some value in this entire value chain, and can be integrated by organization to protect the personal data.
Yes, unless you know that you have at your date. First of all, privacy by design is absolutely necessary to educate people that there is something called their personal data, and also that how far that data is valuable. If you have these two concepts fixed in the individual's mind, then he will think of protecting it. That is why I give you the example of Fort Knox and the London Tower. Once you know how valuable, what is this, probably you have a safe in your house. You don't keep raddi in that. You keep only what is valuable to it. It could be gold, silver, cash, important documents. Those are the things that need to be protected. Why? Because you know their value. And you know how to protect them against people accessing it unauthorizedly. Correct. That is why you are right, it is necessary to have this concept driven home.
Yeah. One more thing that is not part of this entire bill is, of course, one of the sessions someone mentioned that about the bill only talks about the digitized version of data. What about the hard copy?
According to me,
most of our judicial system works on a hard copy. So I think, and you are very close to that system. So maybe you can share some perspective on that.
According to me, that appears to be a loophole in the Act. I do not know why they thought of it. If you remember the 2018 report given by my committee, as well as the draft bill of 2018, had said that the law should be made applicable irrespective of how the data is stored or processed. It should have been agnostic to it. Now, instead of that, they focus so much on digitization that if today, first of all, please understand, there is no law in this country which says that all data should be maintained digitally. It is open to a business entity to say, personal data, I'll keep it offline. Personal data, I'll keep it on a hard copy. Now, if it is legitimately possible, then how do you apply this law there? So that is a big hope. I mean, if a big company, let's say multinational company, which has business all over the world, decides that in India, because this law is there, I'll keep everything offline, there is no way you can touch it. And they will be totally exempted from all these sections that you see in the bill.
Correct. In terms of the obligations of data fiduciary and the consent manager concept that they got, and the deemed consent, the term that they have coined in this particular bill, what do you say about that?
See, consent manager is a good concept. Yeah. I must give them credit for what they have done. See, otherwise what happens, there is this concept known as consent fatigue. That if I have to keep on giving this consent every time, it will be impossible. I may be busy with so many other things. I don't have time to look into this only. Consent manager is like a trustee or a power of attorney holder. He will act on your behalf. He will make sure that he is giving consent only in your interest and only where it is necessary for the purpose for which you want to give it. So consent manager is definitely a good idea, which came about, I must say, in the 2019 bill. And that has been carried on here. There cannot be a complaint about it.
One more addition that they have put in this bill is to create that ecosystem to have consent to be sought in English as well as in around 22.
That was there in the original report also. We had said that India is a vast country where people are not only uneducated, people don't know English. Not only that, we had even said that if you want to take consent, you might have to resort to pictures. Now, for example, if you say there is no smoking in this room, if I don't understand English, I may not know it. Then the question is, In which language are you going to write it? There may be 22 languages. You may not have topic occasion to write it. There, but you put a picture of cigarette with a cross on that, people understand.
Understand.
Poison, how do you show it? Skull and skull bones, isn't it? Therefore, we had said pictographically also put it across. Of course, you have to put it in the state language or whatever is the current language in the geographical area. But pictographically, because the people may not understand how to read also any language. That is necessary, absolutely.
I completely agree with you, and that actually gives us my next question, on which is slightly on the uh, on the guideline which a certain has come up with. Do you think, while it has been debated a lot since last 4 to 5 months, and do you think the organizations are ready to kind of comply with those guidelines and then reporting timelines that they have mentioned?
If you remember, we had also said in the 2018 report as well as the 2018 bill that there should be definite timelines fixed. You know, IT industry is an industry where you can't afford to sit back. IT industry and fire extinguishing, both should be like treated simultaneously as the same. If there is a fire in the house, you are not going to say, aane do, dekha jayega. No. Nor if your IT industry gets affected, you can't sit back and say, dekha jayega, aaj nahi to kal ho jayega. That typical government mentality should not work here. It should be treated as an emergency. We have to deal with it. Of course, there are certain things, there are certain timelines that are necessary. Therefore, we had suggested, in fact, if you know, Reserve Bank has already issued a circular, even before the law became operant, that any bank, Reserve Bank of course is the regulator for banks and payment systems, that any bank or payment system, if it finds a breach in its system, it must within specified period, I think 7 days.
72 hours.
72 hours, report, and within 7 days or 15 days, make a full investigation, make a report.
Oh, yeah.
Isn't it? That is exactly what is necessary.
True.
Now that is a very good way. Now, I don't think this law has really gone into that. Now, interesting thing. Sachin has got guidelines. Those guidelines have no value in law. That is not law as such. This is the law. And unfortunately, this law overrides everything else. So I'm just wondering, if this becomes the law, what happens to all the certain guidelines? Unless they are accepted under the rules or they are formulated as regulations. That is the reason why in the 2018 bill we had said, first establish a data protection authority, ask the data protection authority to continuously interact with the different industrial sectors so that he will understand the best practices, freeze them into acceptable regulations, and then you make the law applicable. Now it has gone the other way. Now the law has come. I don't know what the guidelines are going to be, what the regulations are going to be. Everything is left to the government now.
Agree. I think this guidelines needs to get aligned with the law that is being.
Otherwise the guidelines get overridden because there is a section which says everything else will be overridden.
But from the reporting perspective, you said six hours is a very short time. Organizations are not really ready. But do you think certain as an organization are ready to kind of accept those?
I don't know under what law is certain guidelines being applicable.
So they've been talking about IT Act of 70.
That gets overridden by this. No. The interesting thing is this is an overriding law on data protection. So once this comes into force, everything else pales away. Now, all these guidelines and rules of under the IT Act, they are not going to be enforced against you. This is going to be enforced against you. Now, this doesn't have this, unless it is again brought in by the backdoor method of government rules or regulations. This is the biggest difficulty that I see in this bill.
And what do you see as a what needs to be addressed more concretely? While you touched upon a variety of things right now, but that couple of things or 2-3 things that you want to just get addressed in the.
See, one of the biggest concerns I find in this bill is its inability to take care of the fundamental right of its citizens. I have always said that all laws are intended for citizens. It is not the other way around. So if the law is intended for citizens, the citizen, I always give this example and say it is a triangle where the apex, top apex, vertex is the citizen. One side is the state, the other side is the business and industry. Now, I don't know, for some reason they have really convoluted the whole thing. Now, if citizen is to be protected, how can you say that I will exempt all government departments whenever I want the government wants? If the government does it, then where are we left with? So how do you enforce your fundamental rights? If the government says, no, 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 then I can exempt all this government. If you remember, originally it was conceived of that the data protection law would be agnostic to the person and it would apply across the board to government as well as individual private entities. Now that seems to have been totally inverted.
Yeah.
Now the government is given total blank check. That is the biggest concern. Number two, who is the regulator here? The original 2018 bill conceived of as a data protection authority, it had given an architecture saying that it should comprise of at least 50% or if not more of practicing people who understand the subject, experts on the subject, whether from in this country, foreign country, government nominees, and also be headed by an independent person. There was a modicum of independence ensured to the regulator. Now the regulator is not even mentioned here. Now
They have mentioned a term called board.
but I read the minister's statement yesterday in the paper that he is not a regulator.
He's not.
If it is not a regulator, where is the regulator? If it is a regulator, how is it independent then? If it is to be set up by the government, we don't even know what the member's qualification is, what the chairman's qualification is. Can anybody be made? All government clerks will be members there. Well, if the government wants to do it, they can do it. Therefore, I have a feeling that that is a big lacuna in this bill which needs to be seriously addressed. And I hope government will really address it.
No, thanks, sir. I think that is very helpful to understand your perspective on that. My next topic, or maybe point that I would like to draw attention is a bit of forward-looking.
Yes.
Now we have been moving to, the internet evolution of metaverse and Web 3.0. How do you think, and while having the metaverse adoption, we have seen a lot of enabling technologies being used, AI, ML, virtual reality, augmented reality, and so on and so forth. So, what do you think, what are the challenges from the policy perspective in relation to processing of personal data that may arise in the context of metaverse?
First question that arises is, where does the data reside in a metaverse? That is a question which even technology is unable to answer with 100% accuracy. They say it may probably reside here or reside elsewhere. Now, if you do not identify where the data is in a metaverse, how do you protect it? By law, I mean, technology may protect it. By law, which can you say that it's something like the concept in quantum technology. If you do not know where the atom is going to be or where the particle is going to be, you can't measure it. If you can't measure it, you don't know what its dimensions are, you can't control it. It may be here, it may be there. And as they say, in quantum technology, it depends on the observer. So I have a feeling that we'll get into a situation where the law will be like a dog chasing its own tail till you are able to understand exactly what the many dimensions of the technology are.
Right. Now, given the time, I think, unfortunately, we only have 20 minutes slot, and out of that 20 minutes, I would like to give audience a chance to ask questions. We have any questions to ask, sir?
No questions. I can see somebody's hand moving, but that's not for questions, I think.
That's not for the questions. Yeah.
Let me ask a question. How many of you have really read the bill? Any question? Any hands are coming up?
Yeah, one hand.
One hand, good. So from a technology's perspective, how good do you think is the bill?
Can we have a mic, please?
It's usually the questions to be asked to the panelists, but I'm reversing.
In the front, yeah.
I'm reversing the burden.
Yeah, thank you for giving this opportunity. See, I feel the bill is now drawn at a very, it's at a 30,000 feet level. There are a lot of places where it says, it will be decided as deemed fit to be or something, the words like that. Because your question is about, from technology perspective, how good is this bill or how it can be adopted well. I think there is, for example, consent manager concept. There has to be an entire ecosystem built around that. How do we, enforce that? How do we integrate with different processors and fiduciaries? So the technology element currently is not addressed in this. The other thing is, I would just extend it beyond that is, I would like to put a question to you, sir.
Yes.
The team consent, the way I read it, it looks like it's very open, and a lot of things can be actually fit into the team consent. For example, they gave an example of booking a table at the restaurant. Okay, if the restaurant decides to take three elements, your email address, phone, and the name, do they really need all these three? And it also says about giving a notice that we need these parameters for certain purpose. Now, when we talk about deemed consent, whether notice is mandatory.
No, deemed consent is a situation where the law presumes that the consent has been given by you, whether you have actually given it or not. For example, when you entered this hotel, there must have been a security photo taken by you. Now, you can say, I don't like my photo be taken. The hotel fellow will say, sir, if you don't like the hotel, please don't come into the hotel. Therefore, he can say that the fact that you stepped into across the border where the camera is situated is deemed consent on your part. To what? To come in and use the facility. That kind of deemed consent is acceptable. But in the bill, they have gone into too many deemed consent, and those are going to water down all the rights that the individuals have. And this is saying 1 minute over time, so I'll stop here. Maybe some other forum, some other day, I will expand on it.
Sure,
and
thanks.
I have more than 20 minutes. Thank you.
Well, thank you, sir, and thanks for your time, and thanks for giving us this opportunity to organize this. Thank you.